Welcome and good afternoon, everyone. We appreciate you attending this. On behalf of our New York NBA President, Jeff Pinard, our entire board, and our Education Committee chairs, Elizabeth Cheney and Bill Kennedy, we thank you all for joining today's webinar titled The Anti-Kessler Bill. A couple things that we like to share before we get started here, right? Some housekeeping notes for everyone. Please, if you experience any technical difficulties while you're participating and watching the event here, please use the chat bot function that you see. Just type in there, you'll notify us, and then we'll try to help on the background and make sure that we've got that technical issue corrected for you. We also want to remind you that all of the lines, with the exception of those for our panelists here that we'll be introducing in a minute, they will be muted, so we will not have open lines for communication. Again, please use that chat box for any questions and you want to make comments as they're presenting their information. There's always that opportunity, and we'll do our best to address them. And certainly as we conclude the session, we'll have a little Q&A as well, and we'll address any of the items that we find in the chat box. Also, at the conclusion, we also provide and share all of the slides in this deck that you're going to see here, and any relevant sources and resources that we think are important to you, as well as a little bit more information in the bios on each of our speakers here. One of the other things that we wanted to talk about before we get started, as you can see on the slide there, folks, one of our most important events that we host during the course of the year as well is coming up next week, next Monday and Tuesday. We will be in Albany, New York for our annual advocacy conference. That's going to be the afternoon of the 11th. It's going to be at the Hilton Hotel in downtown Albany. We have multiple legislators coming in to provide updates. We have other speakers as well, and we'll prepare everybody to make the trek up on Tuesday, the 12th. We go up and visit the various legislator offices, make sure we talk to them about bills that we are supporting, bills that we oppose, and provide that information and the resource for these different legislators. So we have that upcoming. We still have ability to accept more registrations or sponsorships. So anyone that's interested in doing that, we certainly would like to provide that opportunity to you. We also encourage any of the individuals here that are attending, if you're not familiar, please become a member of the Mortgage Action Alliance. It's free and easy to sign up. As you can see there, it's directly through the National MBA and through their website as well. But we certainly encourage you folks to do that and learn more information. And be aware, as we post information, but also National MBA, when there's very important legislation moving through, and they're looking for us also to send out notes, whether we're in support or whether we oppose a bill that may be moving through the New York legislature. All right. So with that, we're ready to keep moving forward here. I want to just take a minute here and introduce each of our individual speakers. As you can see up at the top, Brian Goldberg. Brian is the supervising attorney with Gross Bologna. He has been in practice here with real estate. He also focuses on mortgage default servicing, foreclosure litigation, foreclosure trial, federal trial, loan resolution, home retention, eviction, and also title claim resolution. Brian is also an author of Digital Transformations. He's also written numerous papers. He works with various loan servicers and court personnel regarding foreclosure litigation on both forward and reverse mortgages. Our first panelist, Stephen Vargas, as you see there as well. Stephen is the supervising attorney. Oh, sorry, let me advance that back down. Stephen is the supervising attorney at Gross Bologna as well. He's been an attorney there since 2016 and their supervising attorney since 2017. His practice focuses on real estate, mortgage default servicing, foreclosure trial, and appellate court litigation. And he's done that in both federal and state courts as well. And during his 15 years of practice, he's represented note holders, loan servicers, and hundreds of civil appeals in New York State, both with the appellate courts and the Court of Appeals, as well as the Second Circuit Court. Also, as you can see down at the bottom, Zachary Gold. Zachary is a partner with Freedom Vortolo. He's been there and working with them, also with deep experience representing lenders and loan servicers in all aspects of litigation in both state and federal courts. He's been doing that since 2009. He also has very extensive experience in defending clients against alleged violations of federal standards such as TILA, RESPA, FDCPA as well. And then we also have Alexandria Kaminski. Alexandria is a senior counsel with Hinshaw and Culbertson. She has deep experience as well as a litigator. She advocates for her clients also with the focus, as you're hearing here, on real estate, mortgage servicing, foreclosure, and she also handles will and estates in both state and federal courts as well. And prior to joining Hinshaw, she spent 5 years as a Long Island-based firm prosecuting attorney for mortgage foreclosures, both at the trial level and handling numerous surrogate court matters. So very distinguished panel. We're excited. We appreciate everybody signing up and joining this very important event. And with that, Brian, we're going to turn it over to you to start taking us through the agenda here.
Thanks very much, Joe. And many thanks to the entire NYMBA team for working with us and tackling this issue, and it's been an absolute pleasure. And many thanks to all of you here today who have taken the time to be a little bit proactive. Today's presentation is different than most that you are used to. This is not a bill that is currently in effect. This is something that we are looking at down the pipeline. So if the state legislature passes the anti-Kessler bill and the governor enacts it into law, we will be prepared. I know that the industry was hit hard by the initial appellate court Kessler decision, as well as by the Foreclosure Abuse Prevention Act. And it really taught us all a lesson that we do need to be a little bit proactive and make sure that we stay on top of the regulatory issues, such as the anti-Kessler bill, so that if and when it is passed by the legislature, we are prepared, we are ready to go, and your files are in the best possible places. So the best way to do that is to give a little bit of a history of RPAPL 1304, which is the New York State statute that governs the 90-day notice. We'll also provide you today with a procedural history of Bank of America versus Kessler. We will try not to induce any post-traumatic stress from those decisions and all of the reports that were sent back and forth between clients and law firms. And then we will discuss the proposed bill, what exactly it is, how will it affect your files, how will it affect the industry as a whole, and the interplay between the proposed anti-Kessler bill with the Foreclosure Abuse Prevention Act. And then finally, we will discuss the best practices and the recommendations so that we can all tackle this anti-Kessler bill together and make sure that we are standing at the end of this. Next slide, please, Joe. So a brief rundown of RPAPL 1304, which has really been a thorn in the side of the industry since it was enacted. What that statute governs is the 90-day notice, and it states that on any home loan, a 90-day notice must be sent to a borrower who signed the note or the mortgage or any loan modification. And that notice must be sent by both first-class mail and certified mail to the borrower's last known address, as well as the subject property address. The verbiage for that notice is set forth specifically within RPAPL 1304. And that is very important to remember because that is essentially the basis of the Kessler decisions as well as the anti-Kessler bill. So RPAPL 1304 must be complied with strictly with all statutory elements. That is a statutory condition precedent to foreclosure. What that means in layman's terms is that the verbiage that is set forth within the statute must essentially be cut and pasted into your 90-day notices. If any word is different, if there's information that is added into that verbiage, then it can be seen as not strictly complying with the statute, okay? And those notices must be sent at least 90 days before a mortgage foreclosure action is commenced, and there are limited exceptions that we won't even get into today. Keep in mind also that the 90-day notice requirement pursuant to RPA PL 1304 is a defense to a foreclosure action that can be raised at any time up until the judgment of foreclosure and sale is entered. That means that even if a defendant does not file an answer, or they file an answer and do not assert the affirmative defense, they can still bring up the 90-day notice defense within motion practice at any time up until the entry of judgment of foreclosure and sale. Very important. Okay. Next slide, please, Joe. The specific focus of Kessler is on the separate envelope rule, which is subsection 2 of RPA PL 1304. And what that says is that no additional information can be contained within the envelope in which the 90-day notice is mailed. So that it's really a general and vague term and a vague statute that really did not fall under any appellate court decision since it was enacted in February of 2010, until we received the decision from the Appellate Division Second Department on December 14th of 2021 in Bank of America versus Kessler. And Alex will discuss that decision a little bit later, but keep in mind that the separate envelope rule does not, what the Appellate Division said is that the separate envelope rule did not only include additional verbiage within the RPA PL 1304 notice itself. It did not include separate pieces of paper. They specified federal disclosures, bankruptcy disclosures, SCRA disclosures. So just because it was verbiage within the letter, either at the bottom or in the letterhead, that violated the separate envelope rule of 1304 subsection 2. Okay, and Alex is going to discuss that a little bit more with a procedural history of Bank of America versus Kessler. Joe, next slide, please.
Good afternoon, everyone. Let's take a walk back to 2021, like Brian was saying, to the Appellate Division decision of Kessler. So the Appellate Division, that's where the overwhelming majority of foreclosure appeals are heard here. They were tasked with whether additional information included in the notice was a violation of separate envelope rule. They ruled that the separate envelope rule prohibits the servicer from including any additional language other than the statutory language. So any additional material or information whatsoever. So that would include the Fair Debt Collection Practices Act language, the Service Member Civil Relief Act language, any Consumer Financial Protection Bureau language, loss mitigation information, bankruptcy information. Basically nothing other than that statutory language could be included. The courts, in deciding that, stated that they came up with a bright line rule for plaintiffs, which would promote stability and predictability. And they also stated that, well, let's go back. So once they enacted this, once this ruling came down, we saw a lot of chaos. We saw either some voluntary discontinuances and some restarts as statute of limitations had not run. We saw a lot of dismissals. And then we also saw the delayed foreclosure filings, because if you were ready to go ahead and file your action, but now your 90-day notice was bad, so now you had to send out a new notice, wait your 90 days. Here's 3 ways on how the courts decided to apply this ruling. We had courts that immediately applied it. We had a slew of dismissals. We also saw some extreme rulings come out from some judges. One example was a letterhead of the servicer was deemed to be a separate notice. And under the letterhead, it stated something as, do not send mail to this address. And so the judge considered that as a separate notice and a violation of the separate envelope rule and a basis to dismiss the foreclosure action. Some judges instead chose to reject the ruling and carry on as if it never happened. And then some judges decided to stay everything because they knew that it was going to the Court of Appeals and the Court of Appeals would come out with a decision. So they basically did nothing until that was decided by the Court of Appeals. Joe, can we have the next slide? So 2 years after, February 14th of 2023, the Court of Appeals gave us sort of a present on Valentine's Day. They were presented with the question of whether the inclusion of concise and relevant additional information voids a 90-day notice. The Court of Appeals reversed the Second Department holding, stating that the inclusion of concise and relevant information, that it does not violate the separate envelope rule, so your 90-day notice is not void. They stated that the statute contemplates additional information as long as it's not false or misleading, because the statute states shall include instead of shall only include. They also stated that this bright line rule that the appellate division came out with would lead to nonsensical results, which we saw in those extreme decisions with the Supreme Court. And they also stated that that ruling could also conflict with any disclosures that are required under federal law. So basically you had the Second Department rule, nothing other than that statutory language. And if you had anything other than that, you were in violation of the separate envelope rule. So your proceeding can be dismissed. Whereas the Court of Appeals stated, no, you're wrong. We're gonna, as long as it's concise, relevant, not false or misleading information, then it's not a violation of the separate envelope rule.
So clearly, Alex, the legislature did not like the judiciary's decision here, and it's been a war back and forth with Kessler really being the cherry on top of that ice cream sundae. And as a result, the legislature proposed this anti-Kessler bill, which is currently in the state legislature. So Steve, why don't you provide everyone with a rundown of the history of the bill so far and where we stand to date?
Sure. Good afternoon, everyone. Thank you for attending our webinar today. Although the servicing industry greatly appreciated the practicality of the Court of Appeals Kessler decision, the legislature did not share that sentiment because on March 17th, 2023, about a month after the Kessler decision, the state Senate introduced the Anti-Kessler bill to overrule the Court of Appeals Kessler decision and impose new requirements related to the 90-day notice. Senate Bill 5829A is the Senate bill. Assembly bill is 5841. Referred to the Housing, Construction, and Community Development Committee on January 3rd, 2024. The Assembly bill was 5841. The bill unanimously passed the Assembly on June 1, 2023, but died in the Senate. However, major concerns arose from the existence of the bill, in part because Senator James Sanders Jr. Was a co-sponsor of the Foreclosure Abuse Prevention Act, which unfortunately everybody's well aware of as a problematic piece of legislation that we had to address. He was actually the Senate sponsor of the Foreclosure Abuse Prevention Act. The legislature has not taken any action on these bills, in part because its focus has been on redistricting and will shift primarily to the budget before taking up most bills. After the budget negotiations are complete and a budget has been approved, it's possible there will be additional traction with respect to the anti-Kessler bill. And just using an example, the Foreclosure Abuse Prevention Act is a piece of legislation we can examine and compare with what we're currently dealing with the anti-Kessler bill. The Foreclosure Abuse Prevention Act didn't have any movement with the pieces of legislation until May 2022. It was introduced in 2021, similarly in response to the Freedom Mortgage versus Engel case to overrule that decision. But nothing happened with FAPA. FAPA was introduced in 2021. There was no real movement on FAPA until 2022, when the legislature quickly, the Assembly and the Senate quickly passed the bill in May 2022. A period of time elapsed before the bill was delivered to the governor, and then the governor signed the bill towards the end of the year. In our situation, we shouldn't have a false sense of security because the bill hasn't been passed by the Senate and the Assembly yet. It's worth noting that it passed the Assembly unanimously last year. And although we're early in the legislative process in 2024, certainly the the situation where we have a body of the legislature unanimously approving the legislation. Even some people who objected to the Foreclosure Abuse Prevention Act were in favor of this legislation. So I think it's something to mention that although the legislation hasn't moved in the last 2 months, there's certainly a possibility in the next 3 or 4 months the legislature could act swiftly on this. And like I mentioned, unanimously passing the bill is a major concern because about 20 different people in the assembly voted from yes to object FAPA, and now they're in favor of the anti-Kessler bill. So next slide, please.
Joe, can we jump forward 2 slides?
Yep, this one. Thank you. As far as what it is, because when you heard from Alex, you heard from Brian what the current version of the statute is, and then you heard from Alex how the Second Department interpreted it in such a problematic manner, and how the Court of Appeals interpreted it in a very rational manner, obviously very favorable to the servicers because based on the Court of Appeals ruling, the vast majority of 90-day notices would not be deemed, quote, void, using a term used by the Court of Appeals in their Kessler decision. Like we mentioned, the remedial bill, remedial is the same type of term that the legislature used for the Foreclosure Abuse Prevention Act to describe legislation that was overruling a court decision or judicial interpretation the legislature disagreed with. It would overturn Kessler and reinstate the Second Department ruling in which the Second Department held the inclusion of any other mailing or notice beyond the statutorily mandated content would violate the statute and subject a foreclosure plaintiff in a contested foreclosure to potential dismissal if the borrower litigated the defense at any point in the case, like Brian mentioned. It could be brought up in an answer, which then would need to be disproven at summary judgment. It could be brought up in opposition to a summary judgment. It could be brought up in opposition to a motion for a judgment of foreclosure and sale. Obviously, it could be brought up in a cross motion or a pre-answer motion to dismiss. Plenty of opportunities for a borrower to bring up the 90-day notice related defense in the contested foreclosure. And then we'd be forced to relitigate all of the arguments that we had to deal with for the 14-month period when the Second Department's Kessler was, in a sense, the law of the land because it was adopted by the other intermediate appellate courts. Certainly that's problematic. As Alex mentioned, the litany of dismissals, the litany of unusual arguments, and then the challenges and occasionally absurd outcomes and decisions discussed by Alex, we'd be experiencing them again. So the PTSD, so to speak, that Brian mentioned earlier, you remember, cases were on hold, cases were voluntarily discontinued for new 90-day notices to be sent. The foreclosure process was delayed, the timeline was impacted, the escrow advances were continuing, the attorney fees were continuing, all of those negative outcomes. There is no positive outcome that can be discerned from this legislation. And
Steve, you've been the bearer of great news so far. So why don't we just rip the Band-Aid off entirely and tell everybody about what's actually hidden in the bill, those little nuances of the bill that it's being proposed by the legislature that would greatly impact the industry. Joe, next slide.
I don't exactly. To Brian's point, I am not the bearer of any good news today. So maybe you could glean something from any of my colleagues' comments. Objectively, there's nothing I have other than maybe saying the bill has not passed yet as far as the status of it. But even that, I cautioned to rely too much on. What's hidden in the sponsor's memorandum is effectively clarification or explanation or interpretation of what some of the statutory amendments are. So although the bill was simply the initiative for the bill was to overrule the Kessler decision, just like the Foreclosure Abuse Prevention Act impetus was to overrule the Engel decision, the legislature went beyond simply saying we're going to reinstate the Second Department's decision about the separate envelope rule, which in itself would be problematic enough. This impacts foreclosures in ways that were not previously impacted and actually creates a little bit of tweaking of statutory text combined with an explanation by the Senate sponsor, Julia Salazar, as to what the amendments mean to clarify that there's an even more problematic perspective of the anti-Kessler legislation. The second bullet point we have here is that it's simply there's clarification that the 90-day notice shall not be sent by a lender, assignee, or servicer who lacks authority to enforce the mortgage loan. It's in some sense creating some sort of standing burden for the mailing party or the plaintiff to show that they had legal authority to mail the 90-day notice. In my estimation, that's not a huge problem. Standing is a defense that it used to be very challenging to overcome just with certain evidentiary requirements and difficult judges. That defense has been, it's lost a lot of its teeth, so to speak, and it's a lot easier to disprove and overcome a standing defense. And really, practically speaking, the servicer or the lender that's mailing a 90-day notice certainly has authority to service the loan or as the owner or holder of the loan. So that's not so much an issue. The clarification can be addressed in motion practice or in litigation with a simple statement in an affidavit. The real impact is the last bullet point here. The 90-day notice can only be sent by a lender, an assignee, or a servicer. Okay, well, that's exactly what subsection 1 of the statute says. Currently, that aspect is not changed. However, the clarification, specific clarification, and I'm quoting it mostly verbatim in the bullet point here, the 90-day notice cannot be sent by any entity other than lender, assignee, servicer. So the legislature said, well, we came up with those three terms for a particular, or those three entities, parties for a particular reason. We meant no one other than that, meaning no mailing vendor, no law firm, no other third party. Again, direct quote from the sponsor's memorandum in the Senate. That's a concern because there had not been a prior appellate division judicial determination that a law firm, a mailing vendor, or some other third party couldn't mail the letter as long as there was authorization to do so. So maybe a power of attorney. Obviously, a law firm being retained by the servicer would have authority in the attorney-client relationship to mail the 90-day letter on behalf of the servicer or the plaintiff. Unfortunately, this piece of legislation tries to significantly narrow that. And even though we have favorable appellate division decisions where the appellate courts said, in this instance, a law firm mailed the 90-day notice, proof of mailing by an employee of the law firm was submitted to the court to prove the notice was properly addressed and mailed. Therefore, the plaintiff met its burden to demonstrate compliance with the statute. Or the appellate division, in a number of instances, and the trial courts as well, have specifically referenced certain mailing vendors that do more high volume mailings for the servicers. And the appellate and trial courts are very familiar with these entities. They've seen them at limited issue trials. They've seen their affidavits and business records in motion practice, and they've seen them in appellate records. So they're aware that in some instances, a servicer would retain a mailing vendor. A reason behind that is a mailing vendor, its business practice is to ensure documents are properly addressed and mailed and to retain contemporaneous records that make it easy to prove the documents were addressed and mailed. This legislature, in my opinion, disingenuously, simply didn't care and claimed that that was some sort of, that created a defect in the mailing process for the 90-day letter. I mentioned Flagstar Bank versus Mendoza here because it was mentioned specifically in the sponsor's memorandum as a case they also intended to overrule. So like we said with FAPA on its face, or in the introductory materials was responsive to the Engel decision, except they amended 6 or 7 other statutes within the CPLR, the General Obligations Law, and the RPAPL to address other issues. So now you have the New York State legislature going beyond simply reversing a decision they disagreed with, and now creating retroactively, and we'll get into that, Zach's going to get into that part, new requirements. So the fact that the servicers may have gone with a best practice approach, retaining a law firm to mail the letter, retaining a vendor to mail the letter, and have actual proof it was even potentially delivered. USPS mailing records showing the notice was actually delivered to the borrowers, signed receipts. The legislature, for whatever reason, would be suggesting that may not be enough. Now, we'll get into whether, Zach will get into challenges to something like that, but certainly, it's extremely problematic that they're going to take a step further, and now you have facial challenges to the 90-day notice based on whatever the content is, as far as whether it has anything in the footer about a federal, state, or local debt collection related rule. But now you also have issues where beyond the facial challenge, even if the notice on its face didn't include any separate information, you've got the issue of proving that the lender, assignee, and servicer mailed the letter and it wasn't mailed by a law firm, vendor, or a third party. So fortunately for everyone, that is the end of my bad news for today.
Thank you, Steve. And Zach, turning to you now.
But not the end of mine.
Just the beginning, Zach. So obviously,
Yeah.
the legislature, if this bill is passed, is going to provide the servicing industry with a little bit of leeway, right? In terms of getting up to speed and adjusting to the new requirements of 1304. Right, Zach, I would assume?
You're not correct. Hi, everybody. It's a pleasure to be here today. As Brian indicated, I'm going to talk about the impact of this proposed legislation. So many of you may be thinking, what's the big issue? If this legislation gets passed, we'll just change our procedures moving forward. So here's the problem. The legislature, in its infinite wisdom, decided to make the proposed legislation effective immediately and retroactive. Joe, if you could just change the slide for me. So the Anti-Kessler bill includes the same effective language as the Foreclosure Abuse Prevention Act, FAPA, and relies on the same Court of Appeals authority for indefinite retroactivity, and they cite to Gleason v. Michael v. The bill, if it were to become law, would be effective immediately without a grace period. The law would be indefinitely retroactive, including to pending cases in which the 90-day notices were mailed before the bill became a law. And borrowers could rely on the law to relitigate the 90-day notices at any time before foreclosure sale, even in instances where the trial or appellate court has already ruled that the 90-day notices that you sent were compliant. So what does that mean? The plaintiffs' bar, lenders, and loan servicers can anticipate a massive influx in litigation, really on any case where a foreclosure sale hasn't taken place. The litigation that we saw with the passage of FAPA really will pale in comparison to what will happen if this anti-Kessler bill passes. Because 90-day notices are required on all residential foreclosure actions, and the majority of loan servicers use vendors and law firms to assist in mailing these notices. And really the ones that don't, well, their notices are going to have language that is really prohibited by this anti-Kessler legislation. Very rarely do you see 90-day notices that don't have, at least a footnote referencing something that will be a problem as a result of this legislation. The bottom line is that if this legislation passes, a lot of foreclosures are in jeopardy of dismissal. Next slide, please, Joe. So just to recap where we are thus far, the 90-day notices can't have any additional language. No vendor or law firm can mail the notices. The legislation is immediately effective and retroactive, and there's a risk of dismissal on all your foreclosure cases. That's it, right? Well, there is more. Next slide, please. Oh no, there's an interplay between FAPA and the anti-Kessler bill. For those of you that don't know what the Foreclosure Abuse Prevention Act is, it was legislation passed in response to the Court of Appeals decision in Freedom Mortgage v. Angle. And in sort of basic terms, it altered a lot of the law surrounding the statute of limitations in favor of the borrowers, and it really hurt a lot of the lenders. Of particular relevance is the amendment that it caused to CPLR 205A, which is now CPLR 205-A, also known as the 6-month savings statute. The FAPA CPLR 205-A 6-month savings statute permits the original plaintiff that commenced an action that was dismissed due to an RPAPL violation to commence a new action within 6 months from the dismissal, provided it sends new 90-day notice to the borrower, files a new complaint, and completes service of process on all defendants. However, FAPA and the new CPLR 205-A codifies that only the original plaintiff can use the statute. So due to the frequency of loan sales and ownership changes, the requirement that the original plaintiff must recommence foreclosures will prevent assignees from relying on the saving statute, which has the potential to result in more total losses than probably the FAPA statute of limitation amendments caused. Mortgages get sold and transferred all the time. Rarely do you see an action commenced by a plaintiff and then 6 years later, the loan is still owned by that same entity. Also, as many of the lawyers and lenders on this call know, foreclosure actions rarely get completed in 6 years in New York, between settlement conferences, motion practice, waiting a year for a decision, or if you're in the Bronx, never, 2 years for an appeal, referee hearings, orders to show cause, et cetera, et cetera. It's almost impossible to complete a foreclosure action in New York in 6 years. And the fact that only the original plaintiff can rely on CPLR 205-A, when you combine that with the dismissal that is going to be engendered by the Anti-Kessler bill, it could be devastating. So the critical point that I want to leave everyone with is that if this legislation passes, it could result in the dismissal of the majority of pending foreclosure actions. And if your loan has been sold after commencement of an action and it's been 5 or 6 years, a future action could be in jeopardy as it pertains to the statute of limitations.
Zach,
Joe, next slide, please.
Zach, real quick,
Yeah, sure.
On the interplay between the Foreclosure Abuse Prevention Act and the Anti-Kessler bill. Obviously, the industry is waiting with bated breath about the inevitable appellate court decision on the constitutionality of the Foreclosure Abuse Prevention Act.
Mm-hmm.
Is that something that would be analogous to the Anti-Kessler bill if enacted? And would those arguments kind of be aligned?
So great question, Brian. There is some overplay. There are some similarities between the challenges to FAPA and the challenges to this bill, some potential similarities. So the retroactive language, we really targeted that in our legislation as a violation of due process. So because this same statute has that same component, that retroactive component, a similar challenge could be made. You know, there is some indication that you may be able to challenge a foreclosure action post judgment, and we've argued that judgment is property. It's post any once a judgment has been entered, it's akin to property of the plaintiff. I could get into it a little bit more, but there is a possibility of challenging the legislation for being punitive in violation of the Bill of Attainder clause. You know, I can get into it a little bit more later, but the policy behind this legislation is suspect, and I am of the opinion that this legislation is punitive, and it really is meant more to punish the banks and the lenders than it is to facilitate communications with borrowers prior to the commencement of a foreclosure action. If it were, then they wouldn't be prohibiting vendors and law firms from mailing these notices, because they're in the best position to ensure that a borrower actually receives these notices. Who better to ensure receipt than an entity whose sole purpose is to, you know, have protocols and procedures to ensure mailing is properly sent. You know, law firms have a unique appreciation of the law and can understand the need for contemporaneous affidavits of mailing, or you know, the risk associated with not checking, making sure all mailing procedures are strictly followed. So it's a bit of a tangent, but to answer your original question, yes, there are avenues for challenging the statute, particularly the retroactive component. The Bill of Attainder is a bit more of my personal gripe, let's say, but yes, the retroactive component, definitely. All right. Joe, can I trouble you to, there we go. How to comply with Anti-Kessler. So what can we do to be proactive? The legislation it's just proposed legislation. But as Steve kind of touched on before, we've seen what happens with proposed legislation. We saw what happened with FAPA. We were reactive instead of proactive. So what can we do to be proactive? We could remove any extraneous languages from the notices. Loan servicers might want to consider stop using vendors and law firms for mailing. This is going to require loan servicers to really ramp up and beef up their mailing procedures. Law firms, you may want to start screening some of your loans or all your loans to determine really what loans are at risk if this legislation gets passed, so that when it does get passed, you're not panicking to see what your exposure is. And just some food for thought. There may be some tough decisions for lenders coming down the pike. If this legislation proceeds to the next stage, it then becomes a race to see whether you can get to foreclosure sale before the statute gets enacted. So, and we can anticipate borrowers. Anticipate borrowers immediately bringing orders to show cause to stay sales and dismiss actions. So the question for lenders and law firms is, can you get to sale before the legislation passes? What do you do if you're running up against a statute of limitations? Do you sort of preemptively consider discontinuing your action, sending new 90-day notices and recommencing, rather than running up against this race? Brian had brought up the constitutional challenges. We discussed some of those. Okay, now that we've thoroughly freaked everyone out, I wanted just to remind everybody that not all 90-day notices, not all loans are at risk here, because let's say a borrower has defaulted in a foreclosure action, they still can't litigate a 90-day notice defense. The 90-day notice defense is still not jurisdictional. If you're not dealing with a home loan, or if it's a business purpose loan, then you don't have an issue. If the loan has not been assigned post-commencement, then you don't have to worry about the interplay between the Anti-Kessler bill and FAPA. So you're not in the statute of limitations world. And that's really all I have to say about that subject.
Well, thank you, Zach, and thank you to the whole panel. Before we wrap up today, do any of the panelists have anything else they'd like to add or ask?
So Steve, I think you touched on this, the timeline of the Foreclosure Abuse Prevention Act versus the timeline of this Anti-Kessler bill. From what you're seeing, they're similar, is that right?
There are similarities, but there's so much legislation out there, that it's similar. I guess the timeline's similar to a lot of different legislation, but we've got a good comparison point, because the Foreclosure Abuse Prevention Act has the similarity to both. The similarity is the legislature, within a month of a Court of Appeals decision that was favorable to the servicing industry, introduced legislation to overrule the decision. So I think that's a good starting point. It's a remedial bill trying to overrule a Court of Appeals decision. There's another similarity. They were introduced, within a month of the negative decision in the legislature's estimation, did not advance that far in the initial year that after the bill had been created, but the subsequent year is when the Foreclosure Abuse Prevention Act had traction and ultimately was signed by the governor without any sort of amendments. So that's a possibility here. I think those are the main points of comparison. Both were introduced as remedial legislation to overrule a mortgagee-friendly Court of Appeals decision. Granted, although both of them were correct on the law based on a lot of prior precedent, both the Engel decision and the Kessler decision made sense in the end. Not in the legislature's eyes, but I think to attorneys across the board, they made sense overall. So those are the similarities. The fact it didn't progress maybe as far as we would have been concerned about last year doesn't mean that this year it won't. There's no guarantee it progresses this year, but I would not be lulled into just assuming it would go nowhere, because the main concern with FAPA was it went through very quickly once it got momentum. And I want to touch on a comment David Case, one of our industry colleagues, wrote the communists in Albany want to give the free houses, but most importantly, his last sentence, the industry needs to take a more active role than the opposition made to FAPA. I think this is a critical point. So I agree with David, obviously. And I'm not speaking for everybody on the panel. I'm just speaking for myself. Though I think the sentiment is shared, I think, based on the nature of our positions on this. FAPA was there were objections to FAPA. There were letters in opposition. There were meetings with minority conference members. There were attempts made. But I think that the importance of the timing of this webinar, in connection with what Joe mentioned initially about the advocacy week, pivotal next week in Albany, the timing was critical here. We felt that this was an important topic to bring up in the default servicing industry. This is probably the most important legislation that's pending in New York. And when you think about even outside of New York, how many bills nationwide in judicial foreclosure, even non-judicial foreclosure states, could impact the timeline or enforcement ability more than something like this, where when Zach's mentioning every contested foreclosure all of a sudden could be relitigated based on this legislation. So I think there's got to be not only activism on behalf of the servicing industry, but maybe a different approach to it. To say that the deleterious impact of this is extreme, and there's nothing wrong with the Court of Appeals allowing people to get additional consumer protection notices, because that's really what we were dealing with. Alex mentioned it, Zach mentioned it, Brian mentioned it, and I mentioned it. The court, all the servicers were doing was trying to quote bridge the communication gap, which was a term used by the legislature when they came up with the original RPA Appeal 1304 16 years ago. They wanted to bridge the communication gap between servicer and the borrower. Giving information about the FDCPA or the loss mitigation options is certainly, I think, from an objective perspective, doing that. So I think there needs to be advocacy on that point soon.
Steve, another question came across the chat. It's from anonymous.
Brian, can I just?
Yeah, sure. Go ahead, Zach.
Brian, can I just before we switch over to the next question? I just wanted to have a related question to one thing that Steve just brought up. Is a colleague had mentioned to me, well, they can't pass this law because the FDCPA mini Miranda notice is required. We have to send that, and the preemption clause, Article 6, Clause 2 says that federal law essentially trumps state law. And the sponsoring memo discussed this issue. And Steve, I don't know if you want to just briefly opine on does this colleague have a point? Does the FDCPA trump, and is this violative of the FDCPA?
An interesting point, because the Senate sponsor specifically addressed this. The FDCPA has a requirement, to disclose that communications an attempt to collect the debt when it's from a debt collector. And in many cases, we're talking about law firms and servicers that are debt collectors. And that was obviously a source of litigation after the original Second Department Kessler decision, federal preemption based on the FDCPA. The Senate sponsor arguably did the servicing industry a favor to protect them, almost a safe harbor of sorts, to protect the debt collection industry by saying in the sponsor's memo about the anti-Kessler bill that in the legislature's estimation, the FDCPA mini Miranda is not required to be included. The sponsor detailed why. Specifically, the sponsor said that the state debt collection legislation, that the statute itself, affords greater protections to the borrowers than the FDCPA mini Miranda. That's a subjective position, obviously. But in the event that somehow there's a challenge to FDCPA compliance or violation based on a 90-day notice that doesn't include a mini Miranda, the servicer should quickly look to the safe harbor language, which is what I'm calling it in the sponsor's memorandum, which can be used to rebut any sort of FDCPA claim.
Thank you. And Zach, you read my mind.
And one thing
that was the question in the chat regarding the FDCPA. So thank you, Zach. Thank you, Steve.
Oh, okay. Yeah. And I think one thing they also said is that the 90-day notice does not have to be, they kind of insinuated the 90-day notice does not have to be the initial communication. Like if you're worried, send an initial communication and then send the 90-day notice.
Right.
Anyways.
One thing I want to bring up, I want to get to one of the other comments from Roger. If this is, I don't have, this is going to be the law school, it depends response, which is what in law school they always said. The answer to most questions is it depends. If the 90-day notice is mailed by a subservicer, does the subservicer fall within the scope of servicer within the statute? I'm not aware, because there was no challenge before to whether a servicer could use a vendor or a third party to mail the notice. There's no case law from the appellate courts that I'm aware of that would address a subservicer, other than the fact that now a subservicer can do that. It can mail the notice on behalf of a servicer pursuant to a subservicing agreement. So under current law, they can. I think we won't know an answer to something like that for a while, because you're going to need appellate court adjudication of that particular issue, which is a very a nuanced point. As far my answer would be, I think a subservicer should be allowed to mail a notice. It is by definition like a business, a servicer. But we know there'll be litigation challenging it. As like Alex mentioned, an absurd litigation challenge about a company logo in a 90-day letter resulted in dismissal in Suffolk County. So anything's possible. So I did want to touch on that point.
Steve,
yes,
you and I were joking. You and I were joking around that that people could be deputized to send these notices, and we likened it to the good old days when MERS was appointing officers to execute assignments of mortgage. It was more of just a joking conversation, but there is a bit of a tie-in. If there is an agreement between, or a contractual relationship between these subservicers and an agreement, does that circumvent this? But anyways,
yeah, no, it's going to be a topic of conversation and litigation. Alex, do you want to take, or Brian, do you want to take Jay Vent's question about the sua sponte raising of the issue?
Yeah, Alex, let's bring you back into the fold. There's a question about how could a court raise sua sponte, the notice being sent by a third party? How could a court probe into that without some obvious indication in the notice itself?
They could probe into that at the time of trial. They could, by the face of the notice though, so with the wall, what's coming to mind are the notices mailed by Walls. You know that they're mailed by Walls. It says Temecula, California. It has the QR code on there. Everybody's familiar with identifying if they're mailed by a third party or not. So I think that could be one point. Brian, are you thinking something else?
Yeah, I think that what we'll see as some fallout of the anti-Kessler bill is additional discovery demands served by defense counsel and pro se defendants, specifically notices to admit, which in New York you have 20 days to respond to, and it would include something like admit that the attached notice was mailed by a third-party vendor, and they'll attach a copy of the 90-day notice as an exhibit to the notice to admit, and we would either have to object to it or admit that it was mailed by Walls Covius or Lender Live, whatever they're calling themselves nowadays, or any other third-party agent or law firm. That can also be accomplished via deposition, or it could be accomplished via document demands, in which defendants will request agreements between the third-party mailing vendor and the plaintiff or servicer. So be prepared for additional discovery demands. We'll do our best to figure out some sort of an objection, but odds are we will need to admit and provide the documentary evidence showing the relationship and the mailing of the 90-day notices by those third-party vendors or law firms. So good question, Jay. Thank you very much.
Question about the sua sponte portion of the question is interesting, because a judge is not supposed to blindside a litigant. They're only supposed to decide the issues before them. But if the defense is raised, arguably compliance with 1304 is part of our prima facie case. So it begs the question, do we have an affirmative duty to establish that it was properly mailed by someone authorized, or could a court sua sponte say this is an issue?
Exactly. A burden to demonstrate compliance with
Yeah.
every subsection of the statute could arguably include some sort of burden to demonstrate that it was mailed by the lender, assignee, servicer, and not any third party. Now, maybe like you said, specificity by the defendant would probably be needed to prompt the court to inquire into that particular issue. But arguably, like you said, it's part of the prima facie case to disprove or establish prima facie compliance with the particular statute and every one of its subsections. Just like we have to prove that the housing counseling agency was included as part of the showing, we would have to show that it was mailed by a lender, assignee, or servicer, and not any other entity. Like Brian said, there could be challenges to that. There could be ways to try to litigate around it. But certainly the defendants are going to be keenly aware of that, because that's going to be maybe the strongest challenge they can make when a facial challenge would fail.
One other question.
Steve, you just yeah. Oh, sorry, Brian. I just wanted to very quickly bring up one more point that Steve just reminded me of. There is some wiggle room with respect for the geek lawyers in the crowd. There is some wiggle room about when this legislation, about when a defendant can still litigate this defense. So in the proposed statute, it says if the case is sub judice, the defense can still be raised, i.e. you can still challenge, you can still make this anti-Kessler related challenge. It begs the question, are they referring to FAPA's up until judgment is enforced? Or are they saying, more conventionally, what we have always understood, which is you can raise any defense until judgment is entered. And once judgment is entered, that resolves litigation. And the proposed statute is somewhat vague. It says sub judice, and the legislature may have intended it to be up until sale, but they certainly didn't specify that the way that they did or tried to do under FAPA, where they said you can raise this defense up until when the judgment has been enforced. I just wanted to really mention that point.
Thanks, Zach. One other question in the interest of time. I know we have only a couple of minutes left. Steve, we have a question from the world famous Bobby Link. He has a client with the habit of sending 4 notices and 6 different notices in the same envelope. He's repeatedly stressed.
Wait, I'm sorry, say that again, Brian. What is the client doing?
They're sending 6 notices in the same envelope. He's repeatedly stressed.
Just 6?
Only 6. Got to carry the 2 there. Repeatedly stressed that the risk of one notice being invalid because a mortgager argues they do not speak English does not outweigh the risk of a homeowner arguing that all of their notices are invalid because they are not in separate mailings and they are unnecessarily cumbersome.
So they're concerned about one of the language requirements, another very niche issue regarding RPA Appeal 1304 about the language. I hate going with it depends. I'm doing it twice. I thought after law school we wouldn't be but we are anyway, or at least I am. I think it's interesting. Hey, Bobby, you and I had discussed this idea, maybe a year or so ago. I don't necessarily think including multiple versions of a 90-day notice that only include the statutorily mandated content would actually violate the rule. I think there's a compelling argument to be made that complies with the rule. So my short answer would be I think that's okay. With all the defense counsel we deal with, some of whom like to put forth arguments that aren't necessarily genuine, we may see some sort of unusual or creative argument to try to claim that's a violation. I think that would be satisfactory. I don't think the current law or a potential amendment via the anti-Kessler legislation would change that.
Let's wrap it up by doing consensus of the panel for Bobby's question. Steve, I am in full agreement with you. It's one notice, just happens to be in 6 different languages. So I think it complies. Zach?
This is like a sword and shield thing. Like it depends who's raising it. Like if we're raising it, they're gonna rule against us. I am going to say that it is compliant.
Love the cliffhanger there. Alex, what do you think?
I would say compliant, but will depend on what judge you're in front of.
There it is. All right, Alex and I are on
Exactly.
the It Depends train here to end this.
Yeah.
That's as New
Yeah,
York as we get.
I'm also on It Depends train.
So let me toss the mic back to Joe. But before I do that, thank you everybody for joining us. It was a very informative and fun session. I hope you got your time's worth. We know that your time in this industry is very limited. So we thank you for spending the past hour with us. Joe?
Outstanding results, guys. And as you probably saw, we had 91 attendees. So it's a very hot topic. It's a very important topic. And we want everybody to continue to reach out. Thank you, Brian Goldberg and Stephen Vargas from Gross Poloe. We also thank Zachary Gold from Friedman Vartolo and Alexandria Kaminski with Hinshaw Culberson. Very, very informative session. And we look forward to talking about this as we keep moving forward. And again, to finish up, folks, advocacy is next week in Albany. If anyone can join us, we certainly welcome you to do that, not only to learn more about this and other bills, but to help us go up onto the Hill, talk to the legislators, and certainly continue to share our information and our concerns from the industry perspective. So thank you all for attending. Thank you again to our panelists. Have a great day, everyone.